Announcement today of a Commonwealth Integrity Commission, an anti-corruption body nationally that the government is now committed to. It does differ to the sort of model that Labor has been pushing through much of this year, and some of the main differences include the lack of public hearings in corruption cases. It won't have the ability to initiate investigations either, but the government, the Prime Minister and the Attorney-General argue it will be a serious investigative body. Will take cases on referral from other agencies. It will look at law enforcement agencies. It will look at the public sector as well. One of those experts who has been looking at the sort of model that should be put in place nationally and advising both sides of politics on this through the course of this year is the former Victorian Court of Appeal Judge Stephen Charles QC, who joins me now. Thank you very much for your time this afternoon. Look, what do you make of the sort of model that the Prime Minister has announced today under this Commonwealth Integrity Commission?
I haven't heard all that much about it, David. I've only read a summary in an email, and I regret, although we've had a number of meetings with the Attorney-General during the course of the year, in that time we've been telling him about our proposals for a National Anti-Corruption Commission. He has not told us about his proposals, so it wasn't really full communication. I think there are a number of things wrong with his proposal.
So what are they?
Well, in the first place, its jurisdiction is limited to crimes. Now, corruption is not only criminal. There are plenty of cases that there is a borderline which crosses into improper behaviour. Now, for example, if one took the matters which arose in New South Wales and which ICAC investigated relating to the coal mining licences in the Bylong Valley, when ICAC was first warned about these, it came in a telephone call which said, look, there's something wrong going on in relation to coal mining licences in the Bylong Valley. There was very little information. There was certainly not enough information for anyone to make an assumption that there was criminal activity involved. And if this body's powers are limited to a reasonable suspicion of criminal activity, it would not have had the jurisdiction to start an investigation into that. Now, the next thing is no ability to have public hearings. The principal purpose of an anti-corruption body is to expose corruption, and this only happens when you have public hearings. For example, when ICAC in Victoria had one of its first main public hearings in relation to the Education Department, the Victorian public first became aware of serious corrupt activity taking place in the Education Department to the tune of millions of dollars. Until that time, the Victorian public had no idea that there was corrupt activity taking place in Victoria. An anti-corruption body's first obligation is to expose corruption. If this body cannot have public hearings, it will not do so.
Well, just on that point, the Prime Minister says he doesn't want a kangaroo court. Do you accept that at times the fact public hearings have been held have been detrimental?
I accept that they may damage public reputations seriously. I accept that if they take place too often, then that can also be unfair. But the model we have proposed is one which will only operate comparatively rarely. If you look at what's happened in Victoria, the ICAC in Victoria has only had, in 5 years, something like 5 public hearings, and each of them has been extremely successful. Secondly, we have proposed a body that should not and cannot make findings of corruption. Our proposal is a body that makes findings of fact with an ability on the part of someone who's had an adverse finding of fact made to appeal that finding.
So, OK, but just to come back to this argument about public hearings, what's wrong with having a closed process that then makes a recommendation to the public prosecutor and presumably at that point, once any charges are pursued, the public is well aware at that point?
Well, the first thing that's wrong with that is, as I've said to you before, much corruption is not criminal at all. Now, it is simply it will delay for a very long time the exposure of what has happened. If you have a government which is receiving very large political donations, but which is then favouring those who've made donations in relation to any attempt by that body and competitors applying to the government, that is a form of corruption which does not necessarily involve crime at all, and which may end up with the matter being exposed publicly by that body without any recommendation to a Director of Public Prosecutions.
But why, if no law has been broken, should someone be dragged through, even if it is a political party, be dragged through that sort of process?
Because corruption is not necessarily related to criminal activity, and the purpose of a body like ICAC, or like what the judges have proposed in relation to a National Integrity Committee, is to expose corrupt activity. Now, you cannot predict that there is going to be criminal activity demonstrated. The body that we have proposed is intended to have numerous private hearings, very thoroughly investigated before any public hearing would occur. Only when the facts are very well known by that body would there be a public investigation, at which time any person being exposed as having done anything that looks corrupt will be the person responsible. It's intended that that body should not be able to damage the reputations of innocent people.
Finally, Stephen Charles, is what has been announced today a step forward? Do you see this as progress, or do you fear this is going to simply sweep under the carpet these issues?
When the ICAC was first proposed in Victoria in 2013, it was a very weak body which had all sorts of obstacles contained in the legislation, making it very difficult for the body to investigate. The effect of that was that the body was widely described as a sham and a paper tiger, and it was one of the factors which gave rise to the Victorian coalition government losing office after one term. I fear that the body that's proposed now is also going to be shown to be a very weak body, and if the funding proposed is any good indication of what's involved, it is totally inadequate.
So is it better to do this or not do this?
The government, if they had been sensible, would have taken up the work that was being done throughout this year by a number of different bodies, like A.J. Brown's work in Queensland, like the judges group have set out very detailed proposals to the government for the setting up of a National Integrity Commission. They should have joined forces with the people who are trying to establish this. The need for a body of this kind it's not a political bandwagon. 34 judges, senior judges, wrote to the Prime Minister saying we need a National Integrity Commission along the lines that has been proposed by the judges group. Now, that simply has been avoided. The body that is being suggested now is nowhere near what is needed for a proper National Integrity Commission.
Stephen Charles, former Supreme Court judge in Victoria, thank you very much for your time this afternoon.
Thank you.
All right, we'll tackle more of that a little later on the program as well, but pretty clear view there from one of those retired judges that the government has failed here to pick up on the work that they have been doing. We're going to take a quick break now and turn to Donald Trump and his former lawyer, now sentenced to jail. We'll talk to Bruce Walpy about all of that and what trouble that may now cause for the president.